Welcome back. You're watching The Firm. For the second time, the Supreme Court has upheld the constitutional right of states to levy value-added tax or VAT on under-construction property. The Apex Court had taken a similar view way back in 2005 in the Raheja case. Why then did the principle need a relook? And what's the way forward? Paiswani Upadhyay has this report.
Contracts for sale and purchase of property vary across India. For instance, in the south, developers or landowners sell an undivided interest in the land to purchasers under a sale deed. A separate contract is signed between the developer and purchaser for the construction of flats. In Maharashtra and North India, developers and purchasers usually enter into a single contract where flats are sold along with the interest in land. The distinction becomes crucial when looked at from a tax perspective. The Constitution allows state governments to levy tax on goods transfer in a works contract. In this case, it would be the property being transferred. But it doesn't define what a works contract is.
When goods and services are being supplied simultaneously, and when I say goods and services, it means that when a flat is being constructed, so there are various stages where a contract is being signed. If a developer is signing a contract with a contractor to construct a complex or a building, there he is asking him to provide goods and services. That is a very clear nature of a works contract. However, in the absence of a clear definition of a works contract, when a buyer of a flat comes to a developer to sign and signs an agreement to a sale, it is not very clear as to where does whether it's a contract for sale or whether it's a works contract.
Historically, many people were of the view that one has to look at the dominant nature of a contract. A contract may have many clauses and many aspects. One has to go by the dominant nature of that contract. And in a situation where you go to a particular builder, you book an apartment, you choose the apartment, and that apartment will then, as part of the larger complex, will get built, and you will be given possession of the apartment, let's say 3 years from now. In your mind and in the mind of the seller, what is being sold is an apartment, which is a real estate transaction, not liable for VAT, either as sale of goods or as works contract.
In 2005, a division bench of the Supreme Court ruled on this confusion. It ordered, in the Raheja developers case, that the state has the right to impose VAT on sale of under-construction property as it constitutes a works contract. At that time, the Apex Court had clarified that as long as there is no breach of agreement, the construction would be for and on behalf of the purchaser and would constitute a works contract.
A lot of people, at least in North India, were of the view that K. Raheja judgment was very specific to the fact pattern of multiple contracts and not a specific nature that gets usually done in North India, where there's a single contract between the builder and the prospective buyer, which is inclusive of everything. So while you're right that there was an explicit judgment, very detailed judgment, but a lot of people still had this impression that judgment only applied to the facts of that specific case.
And so, 2 years later, several developers, including L&T, approached the Supreme Court seeking clarity if their contracts would qualify as works contracts. A 2-member bench observed that if the Raheja development precedent is accepted, then there would be no difference between a works contract and a contract for sale. The bench pointed out that an agreement of a sale of flat between a developer and purchaser could be for the sale itself and not necessarily for undertaking construction on behalf of the purchaser. Having taken this varying view, the Supreme Court bench referred L&T and several other cases to a larger bench for reconsideration. Last week, a 3-judge bench of the Supreme Court ruled that irrespective of the model of contract, states can levy VAT on sale of under-construction flats, pointing that it involved an element of works contract. The Apex Court reasoned that the work is undertaken by the developer for or on behalf of the purchaser and not for himself or the landowner. The Supreme Court further clarified that the activity of construction undertaken by the developer would amount to a works contract from the stage when the developer enters into a contract with the purchaser, and VAT can be levied only on value addition post the agreement. So, the VAT levy on the purchaser of an under construction flat will depend on what stage of construction that flat is in at the time of purchase.
The court has held that when you sign a contract, whatever has been transferred post that contract would be included in the value of the works contract on which VAT would be levied. Now that's very difficult to distinguish, and very difficult for the authorities also to really monitor. So that is one of the biggest problems which the both developers and the authorities would face in implementing that part of the law. What effectively now has happened because of this judgment is that the entire works contract would be levied to VAT and service tax for both the elements of goods and services which are being transferred, and the entire value would also have a stamp duty to it. So there would be multiple layers of taxation which have now happened.
There is also the fear that this interpretation of a works contract may have a collateral damage on other sectors.
It could potentially, and I'm just sort of speaking off the cuff, it could apply for any customized order. So if you go out to a factory and you place an order for goods that are yet to be produced for you, and they are producing based on your specific order, is there a contract of sale or is there a contract of works? Now in the past there has not been a matter of major debate, because one way or the other VAT gets paid on those products, and therefore under that law tax is getting paid. Unlike real estate, that if it's a completed apartment or a completed project, no VAT can apply, but if it's works contract, then VAT will apply. So while it could potentially alter our thinking on many other types of contract, but this is a unique situation where if it applies, then VAT gets paid, and if it doesn't apply, VAT doesn't get paid, and therefore the stakes are very high in a real estate transaction.
Rajiv further explained it to me that going forward, litigation would be on two fronts. One, states will go after developers to collect past VAT liability depending on the period of limitation under various state laws. Two, developers would like to bring a contractual claim against flat owners where this possible VAT liability was not accounted for. The success of this claim will depend on the specific terms of the contract. In short, this one Supreme Court order is likely to result in large-scale litigation. In Mumbai, Paiswini Upadhyay.
And on that note, we're at the end of time on this edition of The Firm. Thanks very much for watching. Do write in to us. You know where to reach us. We'll see you next week.